Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is March 7th, 2019. This is our bi-weekly community conference call. We'll try to answer your questions to the best of your ability, but it will not create an attorney-client relationship, as you would have heard when you logged into the call. Now, just a quick word here. I didn't have time to go over the questions this morning. So I'm going to go as I go along. I'm reading them. Some of them I did review first few. And also for the next couple of times, we'll probably not be able to do the conference. There are other things that are keeping us very busy. So we'll start again in the middle of April. Okay, that said, let's get started with the questions. The first question is from Lily Anchor. So applied for N400 under 3-year rule, but they are living in different places. So naturalization with the 3-year requires that you live in the same place. But you have other documents, joint stuff, etc. Should I appeal? So you know that you always have the right to apply after 5 years, even if you are living separately. But I personally don't see any harm in an appeal. But this is such a difficult question to answer without knowing more about your case. You should really talk with a lawyer locally and see if you can do an appeal. Depending upon your case, the appeal may or may not be successful. But unless there is something in your history that makes the marriage doubtful, I don't see any harm in applying for an appeal. In fact, I think you should. *5 if you have a follow-up question. *5. Okay. Let's go on to the next question. Manan says, I have an approved I-140 with the previous employer. The date is current. Current employer has started green card. They are going to file PERM. Can I file 485? You cannot file 485 without your old job being available. So if the old job is available, you can definitely start your 485 with the employer's help. You will need a letter from them, a genuine offer. You can then do it. Do you have to join the old company with the same job title responsibility? And the answer is yes. If not, join with the same job title. At least have it available as a future job when you get your green card. Should you transfer the H1B first and then proceed with 485 filing? That is really, it is irrelevant. I don't see any particular order necessary. As long as you intend to join this employer, you can file 485 and then join them on EAD, or you can file H1B. I, of course, always prefer having an H1B in the backdrop, because if something goes wrong with the 485, then you can fall back upon your H1B. *5 if you have a follow-up question on this. *5. Okay. Let's go on to the next question from Adi. I'm on H4 EAD. Oh, guys, you gotta be a little quick about your questions. Okay, let's take this question from Illinois. All right. Okay, Illinois, go ahead. I can hear you. Illinois, go ahead. Area code 847.
Oh, hey, Rajiv. I got a question. This is Andy. So just wanted to check. So for I-140, like when you transfer employers, does it need to be the exactly same job title, or can it be a little bit different if it's still in the same line of business and profile?
Well, there are two different scenarios, actually three different scenarios. One is AC21, where you have filed 485 and after 180 days, you are changing jobs. The jobs only have to be same or similar. The second is this question from Manan that said, well, I want to go back and join the old employer, of course, then the job has to be the same because you're going to an offered position. After 180 days, of course, then you can change to any other job with that employer or any other employer as long as the jobs are similar. The third situation is where you're just transferring the priority date. So you've got an I-140 approval, but you are going to a new employer and they're going to start your green card all over again, and you just want the priority date of the old green card. You can have any job you like with the new employer in that case. So I'm not sure which case you're asking me about. All three are slightly.
No, I think it's the third case. So
third case,
you answered my question.
Third case.
Yeah.
Let's say you have a dual degree in medicine and economics. You could have a green card under a physician's position, but do a second green card under as an economist, and you would still carry the priority date of the green card. Okay?
Sure. Okay, perfect. Thank you.
You're welcome. All right, so now, folks, I just want to point out to you, we're not going to have time for new questions today. I've got to run to another conference. So I'm going to finish these calls, but no new calls, no new questions. Adi says I'm on H4 EAD. Employer is filing H1B because of all this uncertainty with the EAD of H4. Can my employer apply for H1B and green card at the same time? Yeah, they can. If I keep working on EAD, can my employer apply for green card without applying for H1B? Yes, they can. Which is the fastest way to get a green card? That depends upon which country you were born in. If you were born in India, there is no fast way. There could be faster or slower, but there is no fast way. Does having master's equivalent degree from India and a professional accounting license make me eligible to apply under EB2? I don't think so. You've got to apply for H1B quota. Oh, to apply for H1B under EB2? These are two different things. I don't know what you're talking about. I can't understand that question. EB2 is a category for a green card application. H1B is for a non-immigrant visa. If you're asking me, can I fall under master's degree quota? The answer is no. H1B master's degree quota requires a US degree from a non-profit or a state-hosted university. There can be no expedition in the green card issuance process. Star 5, if you have a follow-up question on this, star 5. Press star 5 on your phone. Deepak has had his passport impounded because there is a dowry case against him in India. So there are some questions related to that. I'm not sure I can answer these questions because some of them will require some research and I don't know the answers off the top of my head. I can tell you an interesting situation where somebody went for their, I want to remember whether it was green card. It was for their green card. At the I-485 stage, they got a notice of intent to deny because they had a dowry case pending. So they hired us at that point of time, and we prepared a pretty extensive brief showing the government of the USCIS how these dowry cases were sometimes used fraudulently, and in this case, the circumstantial evidence clearly showed that this was a revenge filing rather than any real merits in the filing, because there were 3 accused, mom, dad, and the ex-spouse, and the cases against the mom and dad were dropped by the court on the same facts, and the only reason our guy was still stuck in the dowry proceedings was because he did not want to go back to India to face the charges because the girl's parents were very politically connected. So in that case, the green card was approved. So I'm not sure what your case is. This happened just a few months ago. But I can tell you this, that this needs some detailed research. I can't really answer any of your questions off the top of my head. Okay. People who are joining now, let me remind you that we don't have time to do new questions. I'll just be able to answer the questions posted and their follow-ups. So, working for Company A laid off our group, revoked the H1B, but within 60 days you filed company B's H1B. Now another company C wants to offer an H1B. They've also started my process. So should I join company C on pending receipt when company B receipt is pending? Is it too risky? Well, I don't know the answer to that question, because technically, what is the worst that can happen? If you join company C and company B's case gets denied, you just have to go outside for visa stamping. It's not the end of the world if you are working for a large company in-house. And I really cannot assess this situation in the few minutes that we have. There are too many things that I would need answers to. But generally speaking, because the worst case scenario is not the end of the world, if you have a good deal, I would definitely file or even join company C. What happens if there's an RFE? Well, like I said, the RFE itself is not a concern. But if there's a company B denial, the worst that can happen is that you have to go outside USA for visa stamping. Do I later need the approval receipt from company B? Is it a good idea to join company C only after I get the receipt approval from company B? Yeah, that would be great if you can wait for the approval. What if company C receipt gets denied? So I don't think there is any safe way of doing this. There's a risk no matter what you do. If you stayed with company B and company B's case gets denied, how does that help you? So being with company B or company C is equally harmful or equally non-harmful in case of a denial of company B's case. So I'm doing a negative analysis. To me, the negative analysis doesn't show any harm greater than you would incur if you join company C, or any security or protection you will have if you do not join company C. So it's your choice. I think you can do it. If company C gets denied, H1B gets denied, and company B gets approved, you will be able to join company B as long as they have not revoked your approval. *5 if you have a follow-up question. *5. New people who are joining, I will not have time for new questions today. I will only be able to do the questions posted and their follow-ups. And we'll also not be available to start calls again till the middle of April. Okay. So let's go to the posted question from Ohio. So let's get Ohio on the phone. Ohio, go ahead, please. I can hear you. Ohio, area code 614. Go ahead. Okay, I'm going to go on to the next question.
Thanks, Rajiv.
Yeah. Go ahead. Okay, I can't hear you. Next question is from Charu. My husband is on H1B, I-140 approved. Can I apply for J1 visa for my graduate studies? Well, there's nothing stopping you from doing it. But because your name is mentioned in the I-140 normally, government can refuse to give you J1 status because you have immigrant intent. It is difficult to predict. Also watch out for the 212E home residency requirement. Okay, but within those two parameters, yeah, you can. *5 if you have a follow-up question. Ohio, I can't hear you. Something is wrong with your telephone, sir. I can see you, but I can't hear you. Okay, let's go on to the next question. I have to mute Ohio again. So Ruchin 1902 says my H1B was denied last year and I got H4. Now 3 companies are filing cap exempt H1 for different clients. My question is, can all 3 go ahead and apply? Yes, absolutely. You can, and the order of approval is not important. The only problem is if you are applying for change of status, so you go from H4 to H1, you have 60 days period to join the company. Okay. Order of approval of H1 will take effect. Whichever comes last will be automatically active. No, all of them will be active and you can choose any one of them. I don't see any risk in filing 3 applications if you have the choice. Star 5 if you have a follow-up question. Star 5. Okay, let's go on to the next question. Mr. Burani has been in touch with me about, we exchanged some emails about O1 visa through a government sponsor, and I gave you my input. I don't have anything else to add. I think I have to again look at the law. I don't know the law off the top of my head. We've done many different kinds of visas for different government agencies. We've even done H1Bs for federal government agencies. I don't recall exactly the law on O1s. EB1B, you and I talked about on the email. I have nothing else to add. So unless I spend some time hitting the books on this, I won't be able to give you an answer. Roll number 22. So you are on L1A maxing out 2020. I-140 is approved. If I don't get approved, I have to leave USA, etc., etc. And the answer is you can opt for consular processing, or you can come back to USA with an L1 after 1 year being outside USA. So consular processing is quite available. I don't see any problem with doing consular processing. So after the I-140 is approved, if the I-140 was not filed requesting consular processing, you would have to file Form I-824, which will then convert your case to consular processing, and the file will eventually be sent to the consulate in your home country or whichever country you are a long-term resident of. Star 5 if you have a follow-up question. Star 5. Okay. Let's go on to the next question. Once again, people who are just logging in, we won't have time for new questions today. I have to go into another conference. So PO Box 8284, I've applied for 485 using cross-chargeability in December 2017. They scheduled an interview, then they canceled it. It's been more than 5 months. Is there anything I can do to get the interview? I did call, but you just said you're under normal processing time. You can try contacting your congressman's office. Other than that, there's really nothing much you can do. Star 5 if you have a follow-up question. Star 5. Okay. Next question, Joe 131, currently on H4, planning to apply for community college. 1 year OPT would be available. See, you have to, in order to be eligible for OPT, you have to have been for a full-time student, I think for 9 months, which is 2 semesters, immediately before filing the application. So you can't do this that only in the last semester you convert to F1. Okay. Star 5 if you have a follow-up question. Okay, SMP 721. Currently with employer A full-time for 9 years, file GC, I-140 is approved. Current H1B expiring in September. Got 2 full-time offers from B and C. Both are interested in filing H1B transfer. I want to join company B. They are insisting you start with the receipt. If I join B, and if H1B gets rejected, do I have 60 days grace period to find another employer? You know, I don't know the answer to that question. Because one thing I do know, that 60 days gets reset every time you file for a new process. So let's say you had 60-day grace period, you joined a new employer, you got the approval, you started working, and let's say you get laid off and you'll have 60 days. But do you have 60 days upon denial? I don't know the answer to that question. I have to look at the regulations. Can I join employer C on my current employer A if my transfer for B gets rejected? I'm not sure I understand that question. In this worst case scenario, can I join employer C or my current employer? Oh, yes, yes. If your current employer, I don't know about C, but if you're C, I don't think so. But if your current employer, employer A, does not revoke your H1B and employer B's case gets denied, you can go back and join employer A, no problem at all. That's clear in the regulations. *5 if you have a follow-up question. *5. Okay, once again, for people who are just joining in, we will not have time for new questions today. Just the posted questions and their follow-ups. Next question is immigrant 1990. Family-based 2A category, December 8/17. Now the question is, the visa bulletin says earlier than this date, not on or before. So will I be able to send? Yeah, of course. So if your date is March 15th, 2019, and the visa bulletin says March 15th, 2019, you can't file because it's not earlier than March 15th. You can only file the month the date moves to a date beyond March 15th. Also, my I-130 is still pending approval. Can I still file 485? Oh, absolutely. If while the I-130 is pending, your date becomes current, you can file 485. *5 if you have a follow-up question. *5. Very good. We are zipping along. For new people, again, folks, I won't have time for new questions. I repeat, I won't have time for new questions today, just the posted questions and their follow-ups. Gokul Srivastava 4, I-485 RFE received and its impact towards EAD card generation. So normally what happens is the 485 RFE should not hinder or slow down your EAD. That's not my experience. Okay, so you should be able to proceed with obtaining the EAD and the advance parole despite the RFE. It should not delay those two documents. *5 if you have follow-up questions. *5. Okay, once again, new people joining in, we won't have time for new questions. I have to be in another conference. I'm just doing questions posted and their follow-ups. Thank you. Pankaj B says, my education is 10 plus 3 and 18 years of work experience. I came to USA, got my I-140 approved. H1 was denied. So I'm on H4 visa through consular process. Denial reason was education. Few are saying employers want to start my H1. Few are saying I need to go with lottery process. Well, if you have not had an H1 approval, you are subject to the lottery. Okay, but you had an H1 approval before because it was the extension that was denied. That you haven't made clear, but obviously if in August 2018 you received H1 extension denial, that means you have an earlier H1B approval. In my opinion, you are not subject to the quota. You are not subject to the quota. Few are saying even if you don't have pay stubs, that doesn't mean anything. Few are saying once premium starts, we'll file H1 based upon approved I-140. I don't think that makes any difference, sir. You are entitled to your H1 extension. Your education is a separate problem. But as far as being subject to the quota is concerned, you are not subject to the quota. Can you get H1 extension if you have time left on your 6 years? Yes. Or if you have a green card going, which is at a certain stage of maturity, based upon that you can get your extension. Important thing is you're not subject to the quota. But your education is a separate issue. I can't really tell you whether you're going to get an approval or not. I'll just take a minute and clarify something. Normally, you can substitute 3 years of experience for 1 year of college. But if you have no college at all, you have 10 plus 3, so that makes it what? 10 plus 3 SSC? That means you got 1 year of college, right? No, there's a diploma. So normally what happens is that if you have no college at all, government has traditionally taken the position that we won't give you an H1B even if you have 12 years of experience. I don't recommend any particular agency for evaluation, but I would recommend that any agency which uses two things. One is a database called Acrao Edge database, EDGE, from an organization called Acrao, AACRAO, American Association of Collegiate Registrars and Admissions Officers. They actually have their own website. You can take a look. If they use Acrao Edge and they use college professors who are authorized to issue college level credits for experience in their own field, and that field is your field, then you are okay. So two things, authorized college professors and Acrao Edge database. You should be okay with any agency as far as I can tell. Okay, star 5 if you have a follow-up question, star 5. Next question is my law question S12345. My employer completed PERM, filed I-140, 485 concurrently. Before filing I-485, I was in OPT STEM extension, which has expired. I-140 is approved. I-485 was filed almost 180 days from today. I'm considering AC21. You can, the way it works is, if you filed your I-140 and 485 together, your 180 days get counted back to the date of the filing as soon as the I-140 is approved. Okay. I have my doubts due to previous incidents. You received EAD and AP. My employer paid for 485 filing fees. They've used company lawyer. Is there anything they could have done differently to prevent me from taking the benefits of AC21 portability? No, my only concern would be that the I-140 should be approved. Can I confirm the approval of the I-140? File a Privacy Act, Freedom of Information Act request. That might do it. I can't tell you what the processing times for all the field offices are. They are online, so you can go online and look them up. USCIS website has them. Do you suggest not to use AC21? If the I-140 is approved and you are covered by the 180-day provision, I don't see any harm in it. It's a pretty solid process. Star 5 if you have a follow-up question. The last question that we'll be able to do today, I'm just making sure that that's all there is. I'm currently in India on a re-entry permit expiring in February 13th of this year. That means it's already expired. I was in USA from August 11th to August 25th of last year, filed N470 from India. I'm taking a trip to USA within a month to mail my re-entry permit application. Well, you've got your re-entry permit application expiration. Be careful. Government can create problems for you. Make sure you have access to counsel, although they can't really, we're not allowed as a matter of right to be there. But it doesn't hurt to check with them in case government gives you problems on re-entry. Can I return to India after USCIS receives the application? Yes. I want to do the re-entry permit and fingerprinting in the same visit. You can ask for an expedite when you file the 131. Ask for an expedite on fingerprints. Will they do it? Will they not do it? I do not know. What documents to be submitted with re-entry permit? I don't know. That depends upon the case. Normally, we submit some justification for the re-entry permit requirements. In your case, if you are working for a branch of a part of a US company outside USA, as appears obvious from your N470, that should be documented. It's a difficult question to answer in the hypothetical. Star 5 if you have a follow-up question. Star 5. All right. So this call is from India. Let's take that. India, go ahead. I can hear you.
Yes, Rajiv, this is Arjun G from India.
Yes, sir.
Can you hear me okay?
I can hear you just fine.
Okay, perfect. So I was in the call from the beginning, but there was some bad quality on my cell phone side. I just missed the first response.
Okay.
How do can I go there and mail the application and also do the fingerprinting in the same visit?
Okay, and the answer is you can try. You can ask for an expedite, that please expedite my fingerprinting. And you have to give a reason why you want that expedited. They may or may not do it, but it doesn't hurt to try. Okay.
They will give me an appointment within a week or so?
I don't know the answer to this question. You can ask for it. I don't know if they'll accede to your request, but it doesn't hurt to ask them.
Okay.
Right.
So if I ask for expedite, they will give me an appointment.
They might expedite. I keep saying the same question, same answer, Arjun. They might expedite. I don't know if they will.
Okay. And so I'll be putting my Indian address in the application form. So how do I request a specific city in the US for my fingerprinting? Because my sister stays in San Jose, Bay Area. So I want to see if I can go to the USCIS center there. How do I do that?
I think the easy thing to do is to, instead of giving your sister's your India address, give your sister's address for delivery of the reentry permit. That way they will schedule you somewhere in that application center area. You know that once your sister receives the reentry permit, that can be FedEx to you or sent to you. Okay.
Got it. Okay.
Now, one more thing you can look into is, again, this is a tertiary issue. We've never run into it, so I don't really know the answer. You can check with USCIS customer service. It might be possible to walk into any application support center with the fingerprinting notice. So I don't know for sure, but that's something you can look into. Call USCIS customer service.
Okay. So, but you answered my previous question. To expedite it, I have to mention in my application form when I file the application, and they may honor it.
Right. You have to give a reason. You have to give a reason, and you can Google USCIS expedite criteria. It tells you the 6-7 reasons why you can expedite anything.
Okay.
All right. So you put a cover letter.
Okay.
You put a cover letter with bold print saying request for expedite.
Okay. I'll do that. Okay.
Right.
Okay. Thank you so much.
You're welcome. Good luck.
And one last question. Currently, the form in the USCIS, it says expires December 2018. Now we are in March 2019. The USCIS website still has the older form.
Yeah, just download the most recent form from the USCIS website. And their websites have whatever the most updated forms are. Okay?
Okay, yeah, I downloaded that, but it still says
doesn't matter.
Expiration date of December.
It doesn't matter as long as
okay, got it.
If you download it from the USCIS website, you're safe. Okay. All right, folks. Very good talking with all of you. I have to run today. We'll see you again in the middle of April or thereafter. Always great talking to you. Take good care, everyone. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.